ASEAN Convention Against Trafficking in Persons, especially Women and Children, International Cooperation. Chapter 6, International Cooperation. Article 18, Mutual Legal Assistance in Criminal Matters. 1. In order to combat offences of trafficking in persons which are transnational in nature, the parties shall, subject to their respective domestic laws, afford one another the widest measure of mutual legal assistance in criminal investigations or criminal proceedings in relation to such offences established in accordance with Article 5 of this Convention. 2. The parties shall carry out their obligations under paragraph 1 of this article in accordance with the Treaty on Mutual Legal Assistance in Criminal Matters. Article 19, Extradition. 1. Each of the offences established in accordance with Article 5 of this Convention shall be deemed to be included as an extraditable offence in any extradition treaty existing between parties. The parties undertake to include such offences as extraditable offences in every extradition treaty to be concluded between them. 2. If a party that makes extradition conditional on the existence of a treaty receives a request for extradition from another party with which it has no extradition treaty, it may consider this convention the legal basis for extradition in respect of any offence established in accordance with Article 5 of this convention. 3. Subject to the provisions of its domestic laws and its extradition treaties, the requested party may, upon being satisfied that the circumstances so warrant and are urgent and at the request of the requesting party, take a person whose extradition is sought and who is present in its territory into custody, or take other appropriate measures to ensure his or her presence at extradition proceedings. 4. A party in whose territory an alleged offender is found, if it does not extradite such person in respect of an offence established in accordance with Article 5 of this Convention applies solely on the ground that he or she is one of its nationals, shall, at the request of the party seeking extradition, be obliged to submit the case without undue delay to its competent authorities for the purpose of prosecution. Those authorities shall take their decision and conduct their proceedings in the same manner as in the case of any other offence of a grave nature under the domestic law of that party. The parties concerned shall cooperate with each other, in particular on procedural and evidentiary aspects, to ensure the efficiency of such prosecution. 5. For the purpose of this article, each party shall designate a central authority to be notified to the depositary of this convention. Article 20, Law Enforcement Cooperation. 1. The parties shall cooperate closely with one another, consistent with their respective domestic legal and administrative systems, to enhance the effectiveness of law enforcement action to combat the offences covered by this convention. Each party shall, in particular, adopt effective measures. A. To enhance and, where necessary, to establish as well as utilize existing channels of communication between their competent authorities, agencies, and services in order to facilitate the secure and rapid exchange of information concerning all aspects of the offences covered by this convention, including, if the parties concerned deem it appropriate, links with other criminal activities. B. To cooperate with other parties in conducting inquiries with respect to offences covered by this convention concerning I. The identity, whereabouts, and activities of persons suspected of involvement in such offences, or the location of other persons concerned. 2. The movement of proceeds of crime or property derived from the commission of such offences. 3. The movement of property, equipment or other instrumentalities used or intended for use in the commission of such offences. C. To provide, when appropriate, necessary items or quantities of substances for analytical or investigative purposes. D. To facilitate effective coordination between their competent authorities, agencies, and services, and to promote the exchange of personnel and other experts, including, subject to bilateral agreements or arrangements between the parties concerned, the posting of liaison officers. E. To exchange information with other parties on specific means and methods used by traffickers, including, where applicable, routes and conveyances, and the use of false identities, altered or false documents or other means of concealing their activities. F. To exchange information and coordinate administrative and other measures taken as appropriate for the purpose of early identification of the offences covered by this convention. 2. With a view to giving effect to this convention, the parties shall consider entering into bilateral or multilateral agreements or arrangements on direct cooperation between their law enforcement agencies and, where such agreements or arrangements already exist, amending them. In the absence of such agreements or arrangements between the parties concerned, the parties may consider this convention as the basis for mutual law enforcement cooperation in respect of the offences covered by this convention. Whenever appropriate, the parties shall make full use of agreements or arrangements, including international or regional organizations, to enhance the cooperation between their law enforcement agencies. 3. The parties shall endeavor to cooperate within their means to respond to trafficking in persons and other offences covered by this convention committed through the use of modern technology. Article 21. International cooperation for purposes of confiscation. 1. A party that has received a request from another party having jurisdiction over an offence covered by this convention for confiscation of proceeds of crime, property, equipment or other instrumentalities referred to in Article 17, Paragraph 1 of this convention situated in its territory shall, to the greatest extent possible within its domestic legal system, a. Submit the request to its competent authorities for the purpose of obtaining an order of confiscation and, if such an order is granted, give effect to it, or b. Submit to its competent authorities, with a view to giving effect to it to the extent requested, an order of confiscation issued by a court in the territory of the requesting party in accordance with Article 17, Paragraph 1 of this convention insofar as it relates to proceeds of crime, property, equipment or other instrumentalities referred to in Article 17, Paragraph 1, situated in the territory of the requested party. 2. Following a request made by another party having jurisdiction over an offence covered by this convention, the requested party shall take measures to identify, trace and freeze or seize proceeds of crime, property, equipment or other instrumentalities referred to in Article 17. Paragraph 1 of this convention for the purpose of eventual confiscation to be ordered either by the requesting party or, pursuant to a request under Paragraph 1 of this article, by the requested party. 3. The provisions of Article 18 of this convention are applicable, mutatis mutandis, to this article. In addition to the information specified in Article 18, requests made pursuant to this article shall contain a. In the case of a request pertaining to Paragraph 1a of this article, a description of the property to be confiscated and a statement of the facts relied upon by the requesting party sufficient to enable the requested party to seek the order under its domestic laws. b. In the case of a request pertaining to Paragraph 1b of this article, a legally admissible copy of an order of confiscation upon which the request is based issued by the requesting party, a statement of the facts and information as to the extent to which execution of the order is requested. c. In the case of a request pertaining to Paragraph 2 of this article, a statement of the facts relied upon by the requesting party and a description of the actions requested. 4. The decisions or actions provided for in Paragraphs 1 and 2 of this article shall be taken by the requested party in accordance with and subject to the provisions of its domestic laws and its procedural rules, any bilateral or multilateral treaty, agreement or arrangement to which it is bound in relation to the requesting party, and the treaty on mutual legal assistance in criminal matters. 5. If a party elects to make the taking of the measures referred to in Paragraphs 1 and 2 of this article conditional on the existence of a relevant treaty, that parties shall consider this convention the necessary and sufficient treaty basis. 6. The provisions of this article shall not be construed to prejudice the rights of bona fide third parties. 7. The parties shall consider concluding bilateral or multilateral treaties, agreements or arrangements to enhance the effectiveness of international cooperation undertaken pursuant to this article. Article 22. Disposal of confiscated proceeds of crime or property. Proceeds of crime or property confiscated by a party. Pursuant to Article 17 or Article 21, Paragraph 1 of this convention shall be disposed of by that party in accordance with its domestic laws and administrative procedures. 2. When acting on the request made by another party in accordance with Article 21 of this convention, parties shall, to the extent permitted by domestic laws and if so requested, give priority consideration to returning the confiscated proceeds of crime or property to the requesting party so that it can give compensation and assistance to the victims of trafficking in persons or return such proceeds of crime or property to their legitimate owners. 3. When acting on the request made by another party in accordance with Article 17 and Article 21 of this convention, a party may give special consideration to concluding agreements or arrangements on sharing with other parties, on a regular or case-by-case basis. Such proceeds of crime or property, or funds derived from the sale of such proceeds of crime or property, in accordance with its domestic laws or administrative procedures. Chapter 7. Final Provisions. Article 23. Establishment of coordinating structures. Each party shall consider establishing coordinating structures in the fight against trafficking in persons, including enhancing cooperation under all areas of this convention. Article 24. Monitoring, reviewing and reporting. 1. The ASEAN Senior Officials Meeting on Transnational Crime (SOMTC) shall be responsible for promoting, monitoring, reviewing and reporting periodically to the ASEAN Ministerial Meeting on Transnational Crime (AMMTC) on the effective implementation of this convention. 2. The ASEAN Secretariat shall provide the support for supervising and coordinating the implementation of this convention and assist the SOMTC in all matters relating thereto. Article 25. Confidentiality of documents, records, and information. 1. Each party shall preserve the confidentiality and secrecy of documents, records, and other information received from any other party, including the source thereof. 2. No document, record, or other information obtained pursuant to this convention shall be disclosed to or shared with any other party, state or person except with the prior written consent of the party which provided such document, record or information. Article 26. Relationship with other international instruments. This convention shall not derogate from obligations subsisting between the parties pursuant to other international agreements nor, where the parties agree, shall it prevent the parties from providing assistance to each other pursuant to other international agreements or the provisions of their respective domestic laws. Article 27. Settlement of disputes. Any difference or dispute between the parties arising from the interpretation or application of the provisions of this convention shall be settled amicably through consultation and negotiation between the parties through diplomatic channels or any other peaceful means for the settlement of disputes as agreed upon between the parties. Article 28. Ratification, approval, and depositary. 1. This convention shall be subject to ratification or approval in accordance with the internal procedures of the parties. 2. The instruments of ratification or approval shall be deposited with the Secretary-General of ASEAN, who shall promptly inform the other parties of such deposit. Article 29. Entry into force and amendment. This convention shall enter into force on the 30th day following the date of the deposit of the sixth instrument of ratification or approval with the Secretary-General of ASEAN in respect of those parties that have submitted their instruments of ratification or approval. b. For any party ratifying or approving this convention after the deposit of the sixth instrument of ratification or approval, but before the day the convention enters into force, the convention shall also apply to that party on the date the convention enters into force. In respect of a party ratifying or approving this convention subsequent to its entry into force pursuant to paragraph 1, it shall enter into force for that party on the date its instrument of ratification or approval is deposited. C. This convention may be modified or amended at any time by mutual written consent of the parties. Such modification or amendment shall enter into force on such date as shall be mutually agreed upon by parties, and shall form part of this convention. D. Any modification or amendment shall not affect the rights and obligations of the parties arising from or based on the provisions of this convention before the entry into force of such modification or amendment. Article 30. Withdrawal. 1. Any party may withdraw from this convention at any time after the date of the entry into force of this convention for that party. 2. The withdrawal shall be notified by an instrument of withdrawal to the Secretary-General of ASEAN. 3. The withdrawal shall take effect 180 days after the receipt of the instrument of withdrawal by the Secretary-General of ASEAN. 4. The Secretary-General of ASEAN shall promptly notify all the other parties of any withdrawal. Article 31. Registration. This convention shall be registered by the Secretary-General of ASEAN to the United Nations Secretariat pursuant to Article 102 of the Charter of the United Nations. Done at Kuala Lumpur, Malaysia, this 21st day of November in the year 2015. In a single original copy in the English language.